Rents accrued and collected after the decease of the testator, interstate, are not assets. Kaler versus Canap, or Brand 241. Whereas the lessor dies before the rent becomes due, the rent goes to the heirs as incident to the reversion, and the executor cannot maintain an action to recover it. Fay versus Holleran, 35 bar 295, where the lease ended in April and the tenant had the privilege to gather rental crops and to pay the rent in wheat in August, and the landlord died in June, held that the rent due in August went to the executor. Wadsworth versus Alcott, 6Y64, where the tenant for life having demised demise promises dies on the after the day the rent becomes due, his executive administrator may recover the rent. But if he dies before the rent becomes due, the rent shall be apportioned portion between the executors and administrators and the reversioners. 1 RS 747 2022. Debts secured by mortgage, bonds, notes, or bills, accounts, money, and bank bills, and other circulating mediums, things in action, and stock in any company, whether incorporated or not, goods, wares, merchandise, utensils, furniture, cattle, provision, and every other species of personal property, and effect not hereafter except assets of partnership in the hands of the surviving partner are not assets to be inventoried by the representative of the deceased partner. He is only entitled to a balance on the accounting and insufficient as the partnership interest in the inventory to state it is the interest in the uncertain balance. Thompson versus Thompson, Brad 24. Things annexed to the freehold or to any building shall not go to the executor, but shall wait a minute now. But shall second with freeholds to the heirs of the devices, except such futures as mentioned in the fourth subdivision of the last section. 8. The right of a heir to any property not unmerited in the preceding succession, which by the common law would descend to him, shall not be impaired by the general terms of that section. 9. Page 83, and amended by Chapter 782 of Laws of 1867, when a man having a family shall die, leaving a widow or a minor child or children, or a widow shall die leaving a minor child or children, the following articles shall not be deemed assets for the purpose of distribution: the payment of debts and legacies, but shall be included and stated in the inventory of the estate without being appraised. All the spinning wheels, weaving looms, and stoves put up and kept for use by his family, the family Bible, family pictures, school books used by or in the family of such deceased person, and books and not exceeding in value $50, which were kept and used as part of the family library before the decease of such person, are sheep to the number of 10, with their fleeces and the yarn and the clothing manufactured from the same, or 1 cow, 2 swine to the pork of such swine, all necessary wearing apparel, bed sheets, and bedding, necessary cooking utensils, clothing of family, the clothes of widow, and her ornament proper for her station, and 1 table, 6 chairs, 6 knives, forks, 6 plates, 6 teacups, saucers, sugar dish, 1 milk pot, 1 teapot, 6 spoons. By 13 of Chap 782 of Laws of 1867, it is provided that all articles and properties set apart in accordance with law for the benefit of the widow and the minors of minors shall be remain the sole of personal property in such widow after such minor or minors shall have arrived at age. Number 2 SL 1842, Chapter 157, 3 RS 5th edition 170, as amended by Chapter 782, Laws of 1867. Where a man having a family shall die, leaving a widow and a minor child or children, or a widow shall die, leaving a minor child or children, they shall be inventoried by the appraisers and set apart for the use of the widow, or for those use of the such widow or child or children, or for the use of such child or children in the manners now prescribed by the ninth section above quoted, necessary household furniture, provision, or other personal property in discretion of the said appraisers to the value of not exceeding $150, in addition to the personal property not exempt from appraised by said section. See Sheldon and Visit Bliss, 8 New York 31, Clayton versus Wardell. The appraiser shall use their discretion in this case as what articles they shall set apart, not whether they shall set apart any or not, and if they neglect to set apart articles at all, or set apart less than 150 application, appraiser to perform the duty or the final settlement, he will order the sum of such much appraisers neglect to set apart to be paid to the widow or minors, they having a right to the provision of against next in kin, legatees and creditors. 11 2RS 84 3RS 5th edition 170. The inventory shall contain a particular statement of all bonds, mortgages, notes, of other securities for the payment of the money belonging to the deceased, which are known to such executor administrators, specifying the names of debtors in each securities and the date, the sum originally payable, the endorsement thereon, if any, with their dates, and the sum which in the judgment of the appraisers may be collectible on each security. It should also class the claims inventory as good, doubtful, or bad as they estimate them. 12. The inventory shall also contain an account of all monies, whether in specie or bank bills or other calculated medium belonging to the deceased, which shall have come into the hands of the executor or administrator, and if none shall have come in his hands, the fact shall be so stated in such inventory. It may oftentimes occur that before the appraiser, the executive administrator may have paid out some of the money which came into his hands from funeral expenses, surrogate fees, or other necessary charges, but he should state as the inventory the amount which came originally into his possession, and charge in his account what he may have paid out. Claims of the deceased against the executor administrators must be inventory as other claims and are deemed to be collected by him and as money in his hands from the time of inventory. Decker versus Miller, 2 page 149. Where by the will or death the demand of the testator against any executor name or against any other person is discharged or banquet, discharge or banquets shall not be valid as against creditors of the deceased, but shall be constructed only as specific banquets of such debt or demand, and the amount thereof shall be included in the inventory of the credits and the effect of the deceased, and shall, if necessary, be applied in the payments of his debt, and if not necessary for that purpose, shall be paid in the same manner or proportion as others specify legacies. 2RS 84 This is the statutory application of the principle that no gift is valid as against creditors. Upon the completion of the inventory, duplicates shall be made and signed by the appraisers. Okay, upon the completion of inventory, not exceeding 4 months, others shall be returned to the secretary within 3 months from the date of letters, or in such further time, no exceeding 4 months, as the secretary shall for a reasonable cause allow. On the return of inventory, the executor or the administrator shall take a subscribed oath prescribed by law, which shall be endorsed upon and annexed in the inventory. See form appendix, which may be administered by the official competent or administrator at oath. In addition to the provision of favor of the widows and minor children from the personal estate. Okay? The end.